Hi, my name is Lyndon and I am an outreach organiser here at the Young Workers Centre.
I'm Shannon Bethune. I'm a solicitor here at the Young Workers Centre.
We're here at the beautiful Trades Hall Council building here in Carlton to talk a little bit about the National Employment Standards, also commonly known as the NES. Today we'll talk a little bit about some of the background, some of the history of the NES, and then a few of the specific NES provisions that we think are really important for young workers. Before that, we'll tell you a little bit about what we do here at the Young Workers Centre. The Young Workers Centre provides workplace rights training to high school and TAFE students, and we also run campaigns and events about broader systemic issues that we think are important for young people.
We're also a fully accredited community legal centre. We give free confidential legal advice and support to young workers 30 and under with a range of employment issues ranging from discrimination to dismissals to underpayments and so on.
So let's get to chatting. Shannon, what exactly are the NES?
Okay, the National Employment Standards, also known as the NES, are contained in the Fair Work Act, which is the primary instrument that deals with employment relations in Australia. So the National Employment Standards, there are 12 of them at the moment. They apply to the majority of permanent employees across the country. They can be understood as a bit of a safety net entitlement, so things like employment contracts can't provide for less than or be worse than the minimum terms contained in the National Employment Standards. So casual employees also have access to a handful of those National Employment Standards, but not that many, but we'll get into that later.
It's important to know that these aren't your only source of rights and entitlements as a young worker. You can also have entitlements and rights afforded to you by contracts, by modern workplace awards, enterprise bargaining agreements, or even different types of legislation. It helps to understand the NES better if you know a little bit about the history of the NES and how they came to be. Shannon, could you tell us a little bit about that?
Of course. So the National Employment Standards in their current iteration, being 12 National Employment Standards, are contained in the Fair Work Act. Prior to that though, they were originally introduced part of the work choices regime. At the time, there were 5 National Employment Standards, and then I believe there were around 10 National Employment Standards when the Fair Work Act of 2009 was passed.
It's good to remember that the NES changes as it already has over the year. The NES aren't static, and it's important to be aware of any changes that might happen as they happen and be aware of how they might affect you. Now that we've spoken about the NES a bit more generally, it's time to get into some specifics. While all of the NES are important, we've chosen 3 that we think are really important for young workers to be aware of. Those 3 are super, casual conversion, and paid family carers and compassionate leave. Alrighty, we'll start with super. Shannon, could you tell us a little bit about super and what the NES says about that?
Of course. So superannuation refers to a payment or a contribution that is made to a superannuation fund, which can be understood to be a bit of a retirement or a pension fund. So presently, employers have legal obligations to be making superannuation contributions to workers' super funds. At the moment, as of January 2025, that superannuation obligation is 11.5% of an employee's ordinary time earnings. So basically, you don't get any super on top of any overtime worked, for instance. So importantly, the superannuation contributions are in addition to your ordinary wages and entitlements. They're generally not inclusive of that payment.
It's important to know also that super is only paid to workers 18 and over. If you're under the age of 18, you only receive super if you work up to a minimum of 30 hours a week. And only once you work that 30th hour do you get the super. No workers at all receive super on overtime hours. Every payslip should list the amount of super for you for that pay period, and your boss has to contribute to your super account every 3 months. It's important to check your actual super account, not just your payslip, and make sure that your boss is contributing the amount that they're required to. Alrighty, let's move to casual conversion. Shannon, what is casual conversion and what does the NES say about that?
I guess it could be helpful to give a brief overview of what casual employment is. So casual employment is not permanent employment. It is basically an arrangement where you don't have an expectation of ongoing work. Basically, the employment can start and end with every shift that you get. Casuals also get an additional 25% pay, which is known as the casual loading. So even though in theory that's what a casual worker is, unfortunately there is rampant casualisation. So a lot of employees who are casual actually work as if they're permanent, so they have consistent hours and there's an ongoing expectation of employment. So if those circumstances apply as a casual, there's an employee choice pathway through the Fair Work Act, which basically enables casual workers who have been employed for at least 6 months or 12 months if it is a small business, who have an expectation or there's an advanced commitment of ongoing employment, to make a request to formally convert to permanent employment. So basically, a casual employee can provide a written notice or request to their boss, who can then deal with that request. If it's not getting anywhere, you can always lodge a dispute or an application with the Fair Work Commission to deal with that request. So if you decide that it is in your best interest to issue a written notification to your employer requesting conversion from casual to permanent employment, just be mindful that you will lose your 25% casual loading.
Yeah, for sure. We always encourage young workers to consider permanent employment if they think that might work for them, because it provides better legal protection from mistreatment at the workplace, as well as affords you access to all of the different kinds of paid leave that are available. More information about casual conversion or the employee choice pathway is available to you in the Fair Work Information Statement. This has to be given to you when you start work, and also after 6 months or 12 months if you're working at a small business. To finish up, let's talk about personal carers, compassionate and family and domestic violence leave. Shannon, could you tell us a little bit about what the NES says about those?
So they're different types of leave that are grouped in all together under the National Employment Standards. They're different kinds of leave that apply to different situations. So firstly, with personal leave, that applies in situations where you're unfit or unwell to work. If you're part-time or full-time, it's paid leave. That applies if, say, you have a physical injury or a mental health injury or illness that prevents you from being able to attend work.
Yeah, absolutely. And this is something we definitely want to hammer home to young workers. You can absolutely take a sick day for your mental health. Your mental health is just as important as your physical health.
In addition to personal leave, which is the sick leave, we also have carers leave. That is also paid to permanent employees, and it applies if you need to provide care or you have caring responsibilities to an immediate member of your family or household. So say your child is sick and you're not able to attend work, you can access paid carers leave as a part-time and full-time employee.
Full-time workers get 10 days personal and carers leave per year, and part-time workers get the equivalent amount based on the amount of hours they work. Casual workers do not have access to paid personal and carers leave, but they do get 2 days of unpaid personal carers leave per personal or caring occasion.
Importantly, when accessing paid personal carers leave, you need to be providing notice of your absence as soon as you can to your boss. You also need to have medical evidence that would include things like a medical certificate to basically prove to your boss that you are in fact unwell and you cannot attend work or you have caring responsibilities. In addition to those leave types, there's also compassionate leave. That applies when there is a death in your immediate family or household, when there is a stillborn, or when a worker or their partner has a miscarriage. It's 2 paid days for each occasion for permanent employees, but it is unpaid for casual workers.
And how is that different from family and domestic violence leave?
So family and domestic violence leave are relatively new additions to the National Employment Standards. So that comprises of 10 days of paid leave, which is available to all workers, including casual workers, if they are experiencing or escaping family and domestic violence.
While these aren't all of the NES, these are the ones that we think are really important for young workers to be aware of. So that's all we have time for today. Just to finish off, it's important to remember that the NES changes, as with all other sources of workplace rights and entitlements. If you want to be a part of changing these entitlements for the better, you can join your union to join the fight for better, safer and fairer workplaces.
Absolutely. Don't forget to contact the Young Workers Centre if you're an employee 30 and under, if you're after free and confidential legal advice and support.